have you heard of any of these lawyers? I've got Robert Cheeley, Kenneth Chesborough, Jeffrey Clark, Matthew DePerno, John Eastman, Jenna Ellis, Michael Farino, Rudy Giuliani, Julia Halia. I got a long list. Have you heard of any of these people?
I have.
Are you aware as to whether or not any of them have faced criminal penalties?
Yes, and also been disbarred or suspended.
Oh, yeah, okay. So they've had some issues, but these are the hand-picked lawyers for Trump. I'm assuming that y'all have never been Trump lawyers, Mr. Trusty or Mr. Costello.
No, I was for a year.
Oh, you were, and you still have your bar card?
I'm sorry?
You still have your bar card?
Yeah.
The House committee held a hearing focused on the weaponization of the federal government. This hearing was part of an ongoing investigation into allegations that various federal agencies, including the FBI and DOJ, have been used for political purposes. The discussion included claims that these agencies were involved in actions that overstepped their legal bounds, infringing on civil liberties, and attempting to influence political outcomes. The hearing featured testimonies from various witnesses, including whistleblowers and former officials, who provided insights into the alleged misuse of power by these federal institutions. Representative Stephen Lynch voiced strong criticism of the committee, particularly targeting Chairman Jim Jordan. Lynch proved how Jordan is constantly kissing up to Donald Trump and how Jordan's actions are motivated more by a desire to stay in Trump's favor than by a genuine pursuit of the truth.
Chairman Jordan started this hearing by saying, quote, "You can't make this stuff up." But anyone who has followed this committee's hearings since the beginning knows that that's exactly what the Republican members are doing in this committee. We've been making this stuff up day after day and pushing out untruths from Jewish space lasers to the big lie. The big lie. Let's start with that one. The claim that Biden lost the election and Trump really won, in spite of the fact that Rudolph Giuliani and his crew brought 60 cases in 5 different states, lost every single case, even before Trump appointed judges. Lost every single case that they brought for lack of evidence. Some of these cases didn't even survive a motion to dismiss. There was just no evidence. And yet, my colleagues on the other side, including the chairman, Mr. Jordan, continue to push that big lie that Trump really won the election. And let's talk about Hunter Biden's laptop. We don't talk about that anymore. That was the smoking gun. That was the thing that was going to prove all these theories about wrongful conduct on the part of the president. And then there was Alexander Smirnov, who Chairman Jordan said he represents the most corroborating evidence that we have. The most corroborating evidence we have until he was arrested. He was indicted, then arrested. He's still in custody. Your star witness. Your star witness. This is baloney. And, you know, Hannah Arendt, who was a historian who was in Germany at the time of Hitler's rise, she wrote a book about the origins of totalitarianism. And she talked about the active, aggressive capability to believe in lies. Not just gullibility, but the active, aggressive capability to believe in lies. You know, just as in Germany, the time and the truth catch up to all those lies. And, you know, there's some good people on the other side of the aisle. And I just worry about your reputations and your family's reputations about pushing this crap. You know, we can disagree about things, but when you're pushing stuff like that is harmful to our democracy, and you're of all people, following Donald Trump, dear God Almighty, that's where you're gonna die on that hill. You're gonna die on that hill. sometimes when someone accuses you of something that you're not doing, they're the ones who are actually doing it. And we're here today to talk about the so-called weaponization of the federal government. So I have here a compilation of letters and interventions that Chairman Jordan has authored and submitted to the 4 cases that are ongoing right now. 3 of them are federal, 1 of them is a state criminal trial. These are all criminal trials in which Donald Trump is a defendant. And so these all represent either threatened subpoenas or attacks on or other types of legal, I guess you'd call it lawfare, attacks on the courts, the prosecutors, and in some cases witnesses. So even up to last week, Mr. Jordan was calling for the investigation of Michael Cohen before he's a witness about to take the stand, and Chairman Jordan went so far to send a letter to the Department of Justice demanding that it investigate former Trump attorney Michael Cohen for perjury. That was last week before he took the stand. Talk about interference with the legal process and lawfare. That's what's going on this committee. And to be honest with you, I agree with Maria Bartiromo, her frustration. We got better things to do than this circus.
Representative Matt Gaetz attempted to turn Representative Stephen Lynch's statement against him. Lynch had remarked that often when someone accuses others of wrongdoing, they themselves are guilty of the same crime.
From the testimony of Michael Cohen's lawyer, Mr. Costello, these days you see individuals running for prospective office who claim, if you elect me, I will bring down this public figure or that public figure who disagrees with my political philosophy. Understand that to destroy a political rival, you need not convict that person of a crime. All you must do is leak the fact that the individual is being investigated for a particular crime, thereby destroying his or her reputation and causing that individual to incur legal fees to defend themselves. The net result is, if you can destroy their reputation and bankrupt them with legal fees, you have effectively eliminated or canceled your opposition without ever convicting them of a crime or getting a civil judgment against them. Mr. Costello, I just wanted to say I felt very seen by your testimony that was provided to the committee. But I want to get back to what Mr. Lynch said previously, that sometimes when you're accused of something, it's actually the people accusing you who are doing that thing. Now, you were accused of illegally dangling a pardon before Michael Cohen, right?
Correct.
And that was a lie.
Absolutely.
That accusation could not withstand any scrutiny or review from the Southern District of New York, where Mr. Goldman worked, where other great attorneys have worked, right?
And where I worked.
Right, but that dangling,
Correct.
that accusation of dangling something improper. Remember what Mr. Lynch said. If you're being accused of that, maybe it's the people doing the accusing. Now, Mr. Trusty, you described a searing fact pattern moments ago. You accused a Department of Justice official of an extortionist ploy to dangle a judgeship before a lawyer to get that lawyer to betray their client, Walt Nada, right?
Yes, I have no reason to disbelieve that lawyer.
And who was the Department of Justice official that engaged in that extortionist ploy?
Well, the lead person in that conversation was Jay Bratt, who's still currently assigned to the Southern District of Florida case.
What is that? I mean, for those of you who've been prosecutors, who've dedicated your lives to the rule of law, what does it tell us about the shape of the legal system that you have people with the ability to do what Mr. Costello laid out in testimony, to charge you with a crime, destroy your reputation, bankrupt you, like they're trying to do to Walt Nada, a patriot who served in our military, and then to hear this claim that they were literally trying to compromise the lawyer? How should we reflect on a legal system that permits that?
It's broken. I had a friend of mine from the Department of Justice text me not too long ago, and he said, it's going to take decades for the department to fix itself. And I love that place. I worked there. I was a prosecutor for 27 years, but I am fearful that we've crossed the Rubicon by being ends justified the means, by engaging in selective targeting and differential treatment. And I don't know how it ends or how it gets better, but I'm happy to at least bring evidence about that issue.
Well, and that's why these hearings are so necessary. I think that we would love to stay well constrained within our Article 1 lane. But when we've got this Article 2 process that is unloading on political rivals in Article 3 courts, as Mr. Costello said, the only way to have a check and a balance on that system is for the Congress to step forward and to utilize its tools, the most profound being the power of the purse, but indeed we have powers of impeachment and oversight that are important as well.
Representative Sylvia Garcia stated that Donald Trump had ample time to turn over classified documents before he was indicted, but chose not to comply. She compared this situation to the Watergate scandal, noting that in both cases, there was a deliberate effort to withhold or cover up crucial information.
Thank you, Mr. Chairman, and to the witnesses, good morning. I apologize. I have a competing hearing that I had to sort of play dual role here this morning. While I miss your opening statements, I certainly have looked at what you were prepared to testify to. And frankly, you know, I have some questions, but I'm just sort of still astounded to hear that some of my colleagues are questioning the timing of the charges and all of this poor little Donald Trump got indicted story. I'm astounded by their claim that there's a two-tier system of justice, all because the twice impeached former president was indicted on charges for mishandling of classified documents and Biden was not. You know, that's the bottom line. Biden and Pence were not. It's ridiculous. And I don't say that as a Democrat or as a member of Congress. I say that as a former judge responsible for upholding our Constitution and the rule of law. Apparently, my Republican colleagues need a refresher on criminal law. To convict someone of a crime, a prosecutor must prove each element of that criminal act beyond a reasonable doubt. Prosecuting someone under the relevant statutes in these cases, a prosecutor would have to prove willfulness. Defendants would have to have willingly withheld these documents. Mr. Hur's report cleared President Biden of wrongdoing. But boy, oh boy, did Trump willfully steal and conceal, new mode of operation there, steal and conceal his documents. In his words, when he realized he had the documents in his possession, he didn't call authorities to come get them like President Biden or Vice President Pence did to correct the problem. No, he thwarted every attempt to have federal prosecutors from coming in. Reports say he said, quote, "What happens if we just don't play," end quote, with investigators, and that he didn't want anyone getting, quote, his documents. His documents. He has some strange belief that classified documents are his and his only. So he lied to his lawyers and he lied to the FBI, pretending he didn't have any more documents, when in fact he instructed his aide to hide those documents around his unsecured property in Florida. We've all seen the pictures. He threw them in bathrooms and bedrooms in a building that had tens of thousands of people come through, where 150 members of his staff worked. This isn't a tiered system of justice. It's just the criminal justice system evaluating the facts. Facts Republicans apparently seem uninterested in and want to totally ignore. Because facts aren't what matter to my colleagues across the aisle, as they have proven today. But regardless of how much they try, in America, no one is above the law, not even the former twice impeached president. Ms. Wine-Banks, you were a prosecutor that worked on the Watergate case. As a former prosecutor, can you speak to what is needed to prove willingness, and do you think that it can be proven in this case with the classified documents?
Absolutely, and I think some of the conduct, which all occurred after he was out of office, including the concealing of the documents, including telling people to delete the video, including everything that he did to make sure that things weren't found. He hid documents from his own lawyer by moving them from where he knew his lawyer would be searching. He caused his lawyer to file a false statement to the FBI about, here's the documents we have. Those are all evidence of his knowledge and his willfulness. He knew he had those documents. He knew he didn't want them to be turned over. And if I could just add, the Presidential Records Act is something that was passed as a result of Richard Nixon's conduct. And so I'm very familiar with it, and it extends to not just classified documents, but to all the records of a president. So he was holding many, many documents that should have been turned over as a routine matter when he left the White House.
And this is opposed to how Vice President Biden and former Vice President Pence handled their requests.
That is correct. And in the case of Biden, the special counsel investigating concluded that there was no evidence of willfulness that could establish beyond a reasonable doubt that he had any knowledge or willfulness in possessing those documents. And there were even specific findings about things like his diaries, which have long been held since Ronald Reagan was president, to be the personal possession. Those are personal documents. Former President Trump tried to say everything is my personal documents. That's not how it works. Personal documents are like the diaries and handwritten notes.
Well, thank you, and I'm running out of time, but would you say that they're really, I mean, I don't even know what this, what are they calling it, legal affair? Or,
Lawfare.
I mean, does that word even make sense?
Well, I had to look it up. It's not one that I had ever heard except in terms of the Lawfare blog. And so I looked it up, and I was quite surprised at what its meaning was in terms of weaponization. And I think, as I was being asked earlier, the Project 2025 is the weaponization of government.
You've talked about earlier Jack Smith's obsession with getting this trial done before, in a speedy fashion, I think before the election, is I mean, it seems to me that in and of itself, all of them are concerned these trials may not happen before the, why does that matter? We want justice done right. That should be the focus, not some artificial timeline.
I think the speedy trial demand betrayed the political underpinning of the entire process. There's no reason for a federal prosecutor with a non-incarcerated defendant to say anything. And if I could just for a quick sec, the model here, there was a real obvious model that would have given us all more faith in this process. That is full transparency on behalf of the Department of Justice. Coming into court and saying, we're turning over everything in discovery, we're ready for trial, but Judge, you tell us we'll show up when we need to show up. We're here for small j justice, not capital J justice, as we used to say at DOJ. That's the problem. That model of transparency and openness, not fighting special master supervision, not appealing everything, not trashing Judge Cannon in Florida, that's what we could have had some respect for and some belief that the process is playing out fairly.
You only bring charges after he announces for president, then of course you want the trials before the election. That seems so obvious, I think, to anyone with common sense. That's what they're trying to do. Now, the good news is it's all falling apart. It's all falling apart, which when you have these kind of cases, maybe that's what we should have probably expected in the end.
Representative Jasmine Crockett sharply criticized the proceedings and raised concerns about the legitimacy of the committee's work. In a particularly pointed moment, she questioned a witness, a former Trump attorney, asking if he still had his bar card. This question was aimed at challenging the credibility of those involved in defending actions she viewed as unethical or illegal, highlighting her skepticism about the integrity of the testimony presented.
This is so interesting. A couple of things. I'm just curious to know, as we're talking about lawyers and the obligations of lawyers, and whether or not maybe the former president has any idea of what good lawyer obligations look like. I'm just going to ask, we're not going to play, we're going to do Miss Winebanks. Have you heard of any of these lawyers? I've got Robert Shealy, Kenneth Chesborough, Jeffrey Clark, Matthew DePerno, John Eastman, Jenna Ellis, Michael Farino, Rudy Giuliani, Julia Halia. I got a long list. Have you heard of any of these people?
I have.
Are you aware as to whether or not any of them have faced criminal penalties?
Yes, and also been disbarred or suspended.
Oh, yeah, okay. So they've had some issues, but these are the hand-picked lawyers for Trump. I'm assuming that y'all have never been Trump lawyers, Mr. Trustee or Mr. Costello.
No, I was for a year.
Oh, you were, and you still have your bar card?
I'm sorry?
You still have your bar card?
Yeah, well, unless I get targeted for daring to represent a former president.
You have absolutely done a lot better than most that deal with him, so good for you. I also want to make sure that we talk about what two-tier really looks like. And Mr. Trustee, since you've been a prosecutor before, I'm curious to know, have you ever had a criminal defendant that had over 80 counts in 4 different jurisdictions and somehow was not held pretrial? I know that you talked in your opening about your interpretation of what speedy trial looks like, and it's really only for those that are held pretrial. And last time I checked, most of the time those people held pretrial, they don't have anywhere near 80 counts pending against them. But I'm curious to know, in your experience, have you ever had someone that had over 80 counts pending in 4 different jurisdictions and they were not held pretrial? Yes or no?
Well, no specific recall,
Okay, all
but
right.
I could answer
That's all
more if you'll let me.
You told me no, and I understand because I hadn't either. So, in addition to that, there's been a gag order, since we're going to talk about the pending trial that's going on right now. Have you ever had a defendant that violated a gag order and then you went to the judge and the judge didn't lock them up and they done it at least 10 times? I think it's 10. I'm losing count right now. Have you ever had somebody violate?
In 35 years, I had never seen a defendant gagged.
Okay, not my question. So you've never.
Well, it's
had
hard
it.
to get to the second
So you've
part
never,
if they're never
you've
gagged.
never had it. You're absolutely right. All right. So finally, when it comes down to intimidating witnesses, because maybe you haven't had gag orders, intimidating witnesses, have you ever had a defendant that you were prosecuting and they were intimidating witnesses and they didn't somehow end up in the clank for at least a day or two?
I've had criminal death penalty prosecutions based on witness retaliation. I'm very familiar with gang cases and mafia cases. Most of those defendants were already incarcerated when they would orchestrate some sort of obstruction.
Okay,
If
so
there's
they-
provable physical violence-based obstruction, it certainly makes sense that they'd be incarcerated.
Thank you so much. And, you know, Mr. Hamilton, I don't want you to feel left out of this conversation. So I'm going to make sure I ask you some questions. Let me know if you're having problems answering them, because they really should be yes or no. Let's see. You're the executive director for the America First Legal, correct?
That's correct.
All right. And America First Legal is a member of Project 2025, which is dedicated to creating the playbook for the next conservative administration and what it calls the Project Pillars, correct?
We are proud contributors to Project 2025.
Okay. And are you familiar with Project 2025's mandate for leadership?
In fact, I am.
Okay. And in fact, you wrote some of the sections of this mandate related to the DOJ, correct?
Sure did.
And the mandate outlines policy priorities for the next conservative president. Is that correct?
It does.
You've done a great job. I just want to let you know. All right, so let's walk through some of the provisions of the mandate. It calls for eliminating the Department of Education, eliminating the Department of Commerce, deploying the military for the use of domestic law enforcement against protesters under the Insurrection Act of 1807. It also has the repealing of Schedule F status for thousands of federal employees to allow a president to replace career civil servants with unqualified partisan loyalists. That's probably my favorite of it. It also prohibits the FBI from combating the spread of misinformation and disinformation, like Russia and China, who are actively trying to interfere with American elections. I don't know why or how anybody can support Project 2025. And I know that there was allegedly a joke about dictators and whether or not that's funny, but in the United States of America, dictatorships are never funny, and Project 2025 is giving the playbook for authoritarianism as well as the next dictator to come in. And I know that you are doing your jobs here by making sure that hopefully some juror turns on and finds some viral moment of you spewing more of the nonsense as it relates to the president. But as practicing lawyers or licensed attorneys, I hope that we can all agree that no one gets indicted because someone says so. There takes a grand jury And the grand jury is comprised of American citizens that sit down and review evidence, and they make the determination. And when and if Trump is convicted, it will be a jury of his peers, and it won't be the President of the United States.
I thought you were